Hey guys, good afternoon. I'm Irvin Bautista and welcome to my vlog. So for today's topic, we are going to actually discuss a matter that is related to the divorce proceedings that I've actually just mentioned. Okay, that I've actually posted on my YouTube channel, and a lot of people have been actually inquiring and have been emailing me, which is which I really do appreciate. Okay, and I hope that I was able to actually respond to you guys. Most of you have responded, and I appreciate you wherever you may be. A lot of you are in Canada. There are some who are in the Philippines. Not for the people who are actually inquiring in Canada, they're not just limited to Alberta. They're also scattered all the provinces in Canada. So divorce, I've been getting a lot of inquiries about the requirements. Okay, in terms of the divorce proceedings, this is governed by the Divorce Act, which is a federally legislated law, meaning this is a law that has been passed by the federal government that applies to all provinces. Just like the US, Canada has what we call provinces. Okay, if the US has states, Canada has provinces. And each province, just like the US, each state or each province has its own legislation. If there are any federal legislation, there are also provincial legislation. Okay, provincial legislation applies only to that certain province. Say, for example, if there's a legislation passed in Alberta, it only applies in Alberta. It doesn't apply to any other province like Quebec or Ontario or Manitoba, Saskatchewan, BC, Northwest Territories. Each province has its own provincial legislation, and that provincial legislation only applies to that province who passed it. Now, in terms of federal legislation, such as the Divorce Act, Constitution, Criminal Code of Canada, that's a federally legislated law, and then it applies to all provinces, notwithstanding. And the Divorce Act is one of them. Okay, let me just recall that divorce has three grounds. One would be separation of at least a year, and then basically cruelty, and then lastly would be adultery. Okay, in terms of separation of at least 1 year, okay, the question really that pops up is, do we need to have some kind of agreement? Okay, that says we are separated on this date. It is ideal to have that kind of agreement, especially written agreement. Okay, let's say separation agreement that you have been separated, because it expedites everything. Okay, there are but it's not mandatory. Okay, to have an agreement, a written agreement. What you can say is, for example, okay, spouse A, spouse B, they decide to actually go and say, well, I don't want to continue with this marriage anymore. Can we just file for divorce? Let's call it quits, move on, part ways, and sever our marriage. If both of you are have decided to actually go for it, then you can just say, okay, when would the separation date be? It could be, okay, let's just go with today. Let's say July 31st, okay, or August 1st, or whatever, right? As long as you have that, that's fine, because the separation has to be at least a year, just to give you the opportunity to reconcile, just in case you do reconcile. Because at the end of the day, when you do separate, it could be emotional decision, or decisions based on emotions. I hate you, I want to divorce you, well, let's separate, right? But 3 months after, 2 months after, I do apologize, and you could reconcile. That's fine. Okay, that's why the Divorce Act actually requires for you to at least be separated for at least a year. Because, I mean, if you're already separated at least a year, I mean, the possibility of you reconciling is not that great anymore. Okay, now the other grounds would be cruelty and adultery. Adultery, regardless whether you're a man, a male, female, regardless of any sexual intercourse with someone else, that's fine. Okay, cruelty could be in the form of, let's say, abuses in the family, mental, physical, emotional abuse. Okay, that can be used as form of cruelty. Now, if, for example, you are separating if you are divorcing using separation of at least a year, if both of you are on board, okay, then basically you can actually file for joint divorce. You don't really have to go for the contested. If, for example, both of you are saying, oh, let's just divorce, that's fine, okay, you can file for joint divorce. But if there's any requirement for that, okay, you should be at least a year. Irvin, say for example, I came from the Philippines January, let's say February 1st, okay, I came here February, let's say, Irvin, I came here June 1st, 2023. Okay, but we have been separated for 1 year. Let's say I have been separated from my spouse since 2020, at the start of the pandemic. So that's already 3 years. Does that count? I just arrived in Canada for since June 1st, 2023. Is that enough for me to file? Other than that, yes, you do meet the grounds for divorce, okay? But the question is, are you now entitled to actually file for divorce? Because one of the requirements in order for you to actually file for divorce is that you are a habitually resident of Canada for at least a year, okay? Why is this important? This is important because a lot of people would be thinking, say for example, so Irvin, at least a year as a resident in Canada. What if I'm studying? Okay, what if I'm on visit visa and I've been extending? Or what if I'm on work permit? Does that matter? Usually, as long as you can establish some form of permanent residency in in Canada, not necessarily permanent residency as immigration defines, but some form of permanent intention to permanently reside in Canada, then that is something that you can do. Usually, people who are on work permit can actually file, because usually work permits can be at least a year. There are some form of permanency there. Students, basically it could be 1 year or 2 years. It's a bit tricky because at the end of the day, you might not be able to hit the 1 year, or you might not be able to hit the intent of actually residing in Canada for at least a year, right? Because say for example, you just came to Canada on a study permit, you wanted to study, usually you could go for 1 year, 2 years, 3 years, 4 years, it depends. But most of you guys are actually studying only for 1 year or 2 years, right? So, Irvin, now I am on work permit, can I actually go and file? Yes. If you have been residing in Canada for at least a year, or no, in the province for at least a year, then you can file for divorce. Okay, you can now file for divorce. You can use that as a ground. Now, Irvin, the question is, basically, Irvin, my spouse is in the Philippines or outside of Canada, or we have been separated for at least 5 years to 10 years. Does it still matter? Yes. Okay, it is. And basically, because at the end of the day, you would have to determine if you don't have any separation agreement and you are considered as you're still your status is still married, there might be some repercussions in terms of your ownership over properties, and that's something that you have to be wary about. Okay, now in terms of cruelty and other grounds of divorce, which is cruelty and adultery, you could go for that. You don't really have to wait for 1 year, okay, but you have to prove that. Okay, if separation for at least a year is the ground used, well, the court and both of you agree, then basically the courts will just have to say, well, they have been separated for at least a year. That's fine. It doesn't matter what kind of reason you have. It could be that because you argued, you had a major fight, or basically because you have been an absentee spouse, or because whatever reason that might be, that's fine. Okay, the courts don't care. As long as you have been separated for at least a year, that's fine. So if, for example, you file for joint divorce and the courts will just have to wait, you just have to wait for 3 to 4 months or whatever, how long that may be. The courts are not inclined to actually hold hearings, okay? Because you don't have to prove anything. Both of you have already decided to part ways. In terms of adultery, it can become adultery or cruelty. It can become quite tricky on that, especially if, for example, the other spouse is not amenable or is not going to agree. Because here, the thing is, you would have to prove to the court that this has been committed, not by you, but by the other person. So if the other person says, okay, I'm fine, okay, I can actually go and make an affidavit, you have to be careful in admitting facts, okay? Because that can be used against you. But the point is, rarely do we see a lot of people use that as evidence, okay? So again, there are 3 grounds: separation for at least a year, cruelty, and adultery. For the adultery and cruelty, the court might be inclined to actually hold hearings, okay, to determine whether this is they are inclined to hold hearings because they want to make sure that this is established. These grounds are established. Someone has committed adultery. Someone has committed cruelty. And usually the one who files for divorce is not the person, it's not the same person who committed those acts. It should be the other one who, in this case, might be the victim. So just be careful, okay? Again, thank you for watching my video. If you do have questions, please feel free to actually email me at irvin.bautista@gmail.com. That would be irvin.bautista@gmail.com. See you next time.